Welcome, everybody, to this webinar presented by the American branch of the International Law Association. We're an organization dedicated to the study, clarification, and development of international law, the advancement of peace, equity, and justice worldwide. My name is Gabor Rona. I'm a member of the ABILA Board of Directors and chair of its IHL committee. This webinar kicks off the American branch's quarterly continuing legal education webinar series. Every 3 months, the American branch will host a free webinar on a different and burgeoning topic of international law. These webinars are affiliated with various American branch committees. Upcoming webinars will include topics from the Law of Sea Committee, International Intellectual Property Law Committee, and the International Law, China, and the Reconfiguration of the Global Order Committee. Subject to the approval by the New York State Continuing Legal Education Board, CLE credit will be offered only to those attending the live broadcast for this webinar. Toward the end of the webinar, I'll provide the CLE attendance code. Please write it down, as you will need that attendance code to request CLE credit. Shortly after the end of the webinar, you'll receive an email with instructions on how to request the CLE credit. Today's webinar is entitled A Report Card on IHL. The panelists are 4 of the most knowledgeable experts on jus ad bellum and jus in bello. Janina Dill is professor of the Blavatnik School of Government at the University of Oxford and co-director of the Oxford Institute of Ethics, Law, and Armed Conflict. Cordula Droog is head of the ICRC Legal Division. Need I say more? Ona Hathaway is a professor of international law at Yale Law School and one of the world's most prolific authors on matters of jus ad bellum and jus in bello, among other areas of international law. Mike Schmidt is professor of international law at the University of Reading, professor emeritus at the United States Naval War College, and a retired U.S. Air Force judge advocate. Let's dive in with the bigger picture. My international law guru, Lou Henkin, is famous for having noted that most states obey most international law most of the time. More recently, Canadian Prime Minister Carney at Davos took a rather different view, speaking of the rupture of the international system. Likewise, Thucydides is making a big comeback these days. Everybody seems to be quoting his observation that the strong do what they can and the weak suffer what they must. In other words, it seems that we're facing not merely the failure of rules in exceptional circumstances, but a profound breakdown of the discipline's authority and legitimacy. Since we're here to discuss perhaps the most venerable, not the most vulnerable necessarily, but the most venerable component of international law, international humanitarian law, let's start by placing IHL in this moment. Ona, you in particular have been quite vocal lately about the fate of the international rules-based order. What's happening? And more importantly, for our purposes, what does it mean for IHL?
Yeah, thank you for that, Gabor, and thanks for the chance to join you today. So we are in a profound moment of challenge for the international legal order that was created in the post-war era. That legal order is grounded on a fundamental principle, which is that states don't use force against one another except in very limited circumstances. That is, if they have a right of self-defense, if they've been attacked, the Security Council has authorized it, or if they've consented to it. That's the list. And that was a profound change from the hundreds of years that had come before. This was a choice that was made after 2 massive world wars where millions had died. The world came together and made the decision that it was going to reaffirm an idea that was first adopted in 1928 to outlaw war, and that it was going to create a set of international institutions based on that central principle. The United Nations, of course, is a kind of key institution. Article 2.4 of the UN Charter has this idea of prohibition on use of force at its core. And that was a foundational principle of the international legal order, and it has been for 80 years. It has not been perfectly observed. We can point to lots of cases where it has been imperfect, and yet it has brought us a far more peaceful, more prosperous world. we're in the midst of a deep questioning of whether that is the world in which we're going to continue to exist. Of course, there's a Russian invasion of Ukraine, full-scale invasion of Ukraine in 2022. China has been occupying rocks, reefs, and islands that have been disputed in the South China Sea for some time. And now the U.S. Seems to be joining in with threats to make Canada the 51st state, to take Greenland, unlawful strikes on Iran. We're talking about the possibility of a new round of strikes in Iran, but of course in the summer, the U.S. took strikes on Iran, more recently, the strikes in Venezuela and seizing Maduro. And all these strikes, the boat strikes that have been happening in the Caribbean, which are not at all based in any of the fundamental principles of international law. And so this seems to be heralding a moment where the U.S. is going from maybe an imperfect defender, but largely a defender of the international legal order, not perfectly consistent. And of course, many people point to U.S. intervention in Iraq as an example where the U.S. previously violated the international legal order. And that, I think, is true. But this is a moment where we're seeing a kind of broad-based willingness to kind of throw the rule book out the window. With the Venezuela strike, which I mentioned, the U.S. didn't even try to make an argument that it was that's grounded in any of the kind of international legal principles. So that is a profound shift. And I think we're hearing the recognition of that. Carney's speech, as you mentioned, Chancellor Friedrich Merz of Germany just said that the world order no longer exists at the Munich conference. I think there's a general recognition that something fundamental has shifted. What does that mean for IHL? What that probably means for IHL is we're going to see a lot more conflict. We're going to see more wars. We're going to see deep destabilization, and more people are going to die. And so IHL is more important than ever before.
Dula, the ICRC is certainly the most engaged international organization defending and promoting IHL. You head its legal division. Is there anything special about IHL that might exempt it from the problems that we're seeing with the deterioration of this world order generally? What's the ICRC's strategy for meeting this moment?
Thank you, Gabor. And first of all, thank you for inviting me to be part of this event. Perhaps I'll start from where Rona stopped, which is IHL is more important than ever because there's likely to be more armed conflicts. And when we talk about IHL, International Humanitarian Law, the law of armed conflict, I think we really always need to remind ourselves what it's about. It's about protecting the victims of armed conflicts. And so before I say anything about the normative framework, I do want to situate it also in the experience of people living through armed conflict and why we in the West often think of this moment as a rupture. I think we have to be aware that for many, many people in armed conflict situations that are very often protracted, people in Colombia, in the Democratic Republic of Congo, in the Sahel, in many parts of the Middle East, in Myanmar, in Afghanistan, have lived through conflict almost uninterruptedly for decades. And so for these people who have lived in conflict situations, there's no rupture. It's just one long, continuous experience of misery. And I think we have to just situate ourselves in there as well. That said, I think what I would like to say about why international law is perhaps exempt, perhaps not exempt, but is special in a certain sense, is that international humanitarian law is of course today part of the international law structure that we've seen since the Second World War and that Una was mentioning. The UN Charter, the 1949 Convention, 77 protocols, but also the human rights treaties, the Law of the Sea Convention. So it is part of this international law order. but it also predates it. It predates it both in terms of the conventions, the 1929 Convention on the Protection of Prisoners of War, the Hague Conventions and Regulations from the turn of the century, 1907, even the St. Petersburg Declaration of 1868, and going back much further. In fact, ever since humanity has fought war, which is probably forever, there have always been rules that set limits to war. These rules have changed over time, but there have always been rules. And these rules have also always tried to protect the most vulnerable, protect the dead, and somehow keep a modicum of humanity in armed conflict situations. Tiny modicum, but still. And so we are now living in a moment of transition, or in a moment of probably increased conflict. And what we see certainly at the ICRC is at the level of both non-international armed conflicts, or civil wars, for those who are not so familiar with the terminology, but also international armed conflicts, or conflicts between states, has been on the rise for the last 30 years or so. But whatever moment we are in, we don't know yet how it will play out. And we don't know the severity of the consequences yet. It's impossible to know that yet. But I think what we can say is that whatever the international order will be, whether it's bipolar, multipolar, whether states have neutral or friendly or enemy relationships, there is no world order that is incompatible with having a modicum of shared humanity, and that is incompatible with basic rules that protect the victims of war. So if we have more wars, international humanitarian law will continue to exist, will be continued to be resorted to. That said, of course, the rules that we know, and we will get more into the details, have been getting chipped at the border. This has been the case a lot in the war on terror. And I think, Gabor, you know that more than many of us. You've worked on this for many years. They've been chipped away on, aspects of, but they don't apply to this particular conflict, or they don't apply to this particular group, or they don't apply to this particular type of conflict. So we're constantly having to defend as well international humanitarian law. And to meet this particular moment, I will just give one example of what the ICRC has decided to do in 2024. It's that we have to base ourselves on what we share and what states share, what is in common. And the fact that all states, and of course, outrage is always a bit selective, but all states and societies are outraged by the violations that we see. And they are lamenting the lack of enforcement of the rules, meaning that they adhere to the rules by and large. And so we have to build on this, and build on the fact that the Geneva Conventions are universally ratified, that it's a universal body of law whose values you can find in all cultures across all regions. And so we have launched a global initiative to galvanize political commitment to international humanitarian law. Because this lament about the lack of enforcement of international humanitarian law is true. There are many mechanisms to adjudicate on international humanitarian law, to have fact-finding, to have commissions of inquiry. But of course, international law as a whole, and IHL in particular, cannot be enforced. And the only way to get better compliance at the end of the day is political commitment. And this political commitment needs to be cross-regional, beyond political groupings, military alliances. And so we launched this initiative together with 6 states from different parts of the world, with Brazil, with China, with France, with Kazakhstan, with Jordan, and with South Africa. We now have over 100 states that have joined this initiative. Practically speaking, we are talking about 7 work streams on particular issues of particular interest or urgency of international humanitarian law, such as the use of informational communication technology, the protection of civilian infrastructure, the protection of hospitals in armed conflicts, but also methodological questions about how to better ensure respect for international humanitarian law. And we will do this initiative for 2 years only. This at least the first phase of this initiative. It will culminate at the end of this year at a high-level meeting hosted by Jordan, also on behalf of the 6 states, to bring states together at the highest political level to recommit to international humanitarian law. Now, sometimes I think back of the 90s and think about the language we had in some of the declarations. I think those days are gone. And today, if we get basic commitment at the highest level for the basic rules of international humanitarian law, we will have gained something.
Well, it's comforting to hear that there is a significant number of states that, in spite of questions about the future of the international rules-based order, nonetheless remain deeply committed to IHL. I want to move to a question about the distinctions between jus ad bellum and jus in bello. Our audience is no doubt familiar with the fact of this distinction, but also that IHL itself is divided into 2 categories: Hague law governing means and methods of conducting hostilities, and Geneva law concerning the protection of persons that are hors de combat. Jus ad bellum, on the other hand, the UN Charter rules that prohibit member states from using or even threatening the use of force, as Ona mentioned, require that there be refraint from use of force, except in the cases of self-defense or in the cases of UN Security Council authorization. And the rules of IHL, traditionally we are made to understand, don't care about equities concerning jus ad bellum. In other words, who the aggressor is, who the defender is, should make and makes no difference concerning the applicability of IHL rules. And yet, with Russia, Ukraine, now US, Venezuela, there are significant challenges that have been posed in the jus ad bellum realm. And I'm wondering what you, as experts, think about the effect of this turmoil in the jus ad bellum realm and its effects on IHL. Mike, how do you view these pressures as to the fate of jus ad bellum? And then, what does that mean for the future of IHL?
Thanks, Gabor. Yeah, let me start with the jus ad bellum. I think the first thing we need to acknowledge is that every use of force engaged in by the United States, even under the Trump regime, has not been unlawful. So, for example, in my view, the counter-ISIS operations in Syria, the recent strikes in Nigeria were lawful because they were conducted with consent of the territorial state, which is itself engaged in a non-international armed conflict with ISIS. And then some operations are questionable. So the one that Ona mentioned, where the United States employed force to take down the nuclear capabilities of Iran, in my view, that was probably a violation of the jus ad bellum, but I have heard colorable arguments that it was not. However, beyond those examples, most of which were continuations of the policies of the previous administration, in my view, U.S. compliance with the jus ad bellum is in free fall. I mean, you mentioned Venezuela. Venezuela is the classic case. I think most people don't realize that the mere deployment of those forces into the Caribbean, the air forces and the maritime forces, combined with threats by the Trump administration, by the president and by others, that in of itself was a violation of the UN Charter's prohibition on the threat of use of force found in Article 2, subparagraph 4. And then when they carried out those threats in order to seize Maduro and his wife, that's just a classic case of a wrongful use of force by one state against another. There's no imaginable justification for that action. You combine that with threats that the president and other senior U.S. officials have made against not so much Canada, because I don't think that threat was credible, but certainly against Colombia, Mexico, and more recently, Iran. Without justification, those were violations. And then, of course, there's the one that everyone's all too aware of, and that's the threat by the United States to conduct operations to seize the territory of a NATO ally by force. I mean, listen, Gabor, you can't make this stuff up. I cannot believe that I recently wrote a post for Just Security on the issue of whether or not the NATO allies have an obligation under Article 5 of the North Atlantic Treaty to come to the assistance of Denmark in the face of an attack by the Americans. I mean, as a guy who spent literally my entire life in and around the military, I would like to remind people that the Danes came to our support in both Afghanistan and Iraq and took casualties per capita on par with our own. So, we are really at a low water mark in terms of compliance with the jus ad bellum. And now we're even seeing the misuse of the jus ad bellum to justify violations. So the boat strikes were mentioned. The boat strikes were justified on the basis of self-defense under Article 51 of the UN Charter. The reason you want to do that is that you can say, and that's why we took those boats out, we were merely defending ourselves. Let's be very clear here. That's a nonsensical argument. No serious international law scholar believes that the transshipment of drugs into the United States qualifies as an armed attack, triggering our right to use force in self-defense. No one does that. Instead, it was used to justify what, in my view, is a violation of the international human rights of the individuals aboard those boats. And also, by the way, it's murder by some of those involved under the domestic law of states that enjoy jurisdiction under international law. Now, what troubles me is that this is coming at the same time that we're seeing a clear, ongoing Russian violation of the jus ad bellum. We've seen that from 2014 when the Russians first moved into Crimea, and then, of course, they seized territory in Donbass and in eastern Ukraine, and then in February of 2022, launched a full-scale attack. So we see two members of the Security Council, permanent members of the Security Council, that are with impunity turning to the use of force. And I'm not seeing the pushback that we would expect. For example, no state has really invoked collective self-defense under Article 51 on behalf of Ukraine. With regard to Venezuela, we see a very weak, tepid response because states are terrified that Trump is going to impose sanctions on them or tariffs. With regard to Ukraine, we've seen sanctions on Russia. We have seen the transfer of arms. So the Europeans in particular are reaching into their pockets to help Ukraine. But listen, the response has not been robust militarily. Imagine how the situation would have been different if in the first days of the conflict, the United States and other NATO partners, NATO allies had declared a no-fly zone. And, this is all coming at a time where we're really seeing a disrespect for international law. I mean, Trump forms his board of peace and then invites Putin and Lukashenko from Belarus who is accepted to be members of the board. We have Trump talking to the New York Times claiming, I don't need international law. And when the reporters say, well, then what are the constraints on your willingness to use force? And the answer is my own morality, my own mind. It's the only thing that can stop me. And if that doesn't terrify you, there's something terribly wrong with your moral compass. And then, of course, as a former JAG, I spent a career in the Air Force as a targeting officer. and then has a judge advocate, to have the Secretary of Defense calling us jagoffs, putting that into a book, and then firing the judge advocate generals of the three services is incomprehensible. So how does this all play with LOAC? I think there's a direct line. Here's what worries me. It seems to me that there's pretty good recent empirical evidence that ad bellum unlawfulness lead to LOAC unlawfulness. We have Russia invading Ukraine. There's not a serious pushback on that. Russia now understands it can get away with violations of the law. And, you know, what Russia has been doing with respect to the law of armed conflict in Ukraine, it's a master class in how to violate the law of armed conflict. So the two are related. Once you get away with being lawless, that applies to both the ad bellum law and the in bello law.
Mm-hmm. Thanks, Mike. Janina, since Mike is making the point that lawlessness in one realm breeds lawlessness in the other realm, I mean, how do you view the present environment for international law generally, for the challenges that are being presented in the jus ad bellum realm, and then that more pointed question about how that may affect the challenges that we're facing now and that maybe we expect to be facing even more so in the future under IHL, the law of armed conflict?
Yeah, I mean, I agree entirely with Mike that just as a matter of fact, lawlessness and the resort to force breeds lawlessness during the conduct of war. And the issue isn't so much the question to what extent there's a gap between what we see, observe factually, and what is permissible under the law on the resort to force. What the actual problem, the primary factor, is in a sense more cynical legal justifications and even performed disdain for international law by political leadership. That sets the tone for the rest of the chain of command. And there's the difference between, for instance, the United States invasion of Iraq in 2003, which was, for all intents and purposes, in tension with the law on the resort to force, and its invasion of Venezuela, right? So not attempting to even to justify your conduct under international law, in some sense, is a much more fundamental repudiation of the authoritative character of international law than is a violation that you then make an effort to somehow squeeze into the acceptable definition exceptions to the prohibition on the use of force, even that if that is implausible. So the performed disdain for international law, that breeds lawlessness on the battlefield. We've seen that with Russia and Ukraine. I agree here with Mike's assessment, where the initial reasoning for why Russia had invaded Ukraine was deeply cynical. And then we've seen over the years targeting in non-compliance with IHL and very obvious war crimes against occupied population and persons in the hand of the enemy. We'll talk more about the boat strikes, but yes, the US institutional and political repudiation of former fidelity to international law has bred both aggression and military and law enforcement operations in violation of international law. Of course, that sort of general lack of fidelity to international law among great powers and other important military powers like Israel has also then had knock-on effects that it's led to underfunding and political pressure on institutions of accountability, the courts predominantly, but also institutions of observation and report. And it has been implicated in a gridlock in the Security Council, the fact that two aggressors in the international system are permanent members of the Security Council. So yes, the international humanitarian law is massively under pressure from the fact that we have this trend line in the international system of a higher number and intensity of armed conflicts, and many of them in direct violation of international law, and with a kind of lack of attempt to justify them even to fit them in the legal paradigm, so to speak. But I'd like to make a point independent of that, which is a sign of IHL resiliency, specifically resilience of the principle of equal applicability of IHL, which has in the last 5 years been under enormous amount of pressure, but has done actually quite well if you think about it. So let me briefly explain that. The strongest imaginable pressure on the equal application of IHL arises in a context like the war in Ukraine, right? You have one obvious aggressor with no access to a potential justification, and one state obviously struggling for survival in self-defense. That really stark legal and also moral asymmetry between two state parties in this context it's quite hard to explain why both sides should obey the exact same rules under IHL. Why Russian soldiers are subject to the same constraints and enjoy the same protections as Ukrainian soldiers. I think that intuition that this is in some sense problematic is then strengthened by the fact that this war really shows up the weakness in the enforcement mechanisms of international law, because the aggressor is a nuclear-armed permanent member of the Security Council. So many of the kind of hierarchical pathways for legal accountability are blocked. And yet we haven't really seen that erosion in the equal applicability of IHL, because there haven't really, to my knowledge, been many high-profile cases of Ukrainian violations of IHL, and because Ukraine hasn't really made a case that it should get away with a looser interpretation of IHL or non-compliance. I should say that I haven't studied this with the kind of rigor of the social scientific approach, but my impression is that one reason for why IHL compliance is relatively robust on the Ukrainian side is that it is actually a means of differentiation from Russia. So we are not Russians, we comply with IHL. And of course, Ukraine is largely fighting on its own territory, which also helps. Now, what could have happened in Ukraine looked for a while like it would happen in Israel, right? Where a belligerent seeks to deflect scrutiny from its conduct of the war under IHL with reference to the urgency of self-defense. So I am of the view that the Article 51 right under the Charter wasn't available to Israel after October the 7th, but this is contested, right? But there's clearly an intuitive plausibility that Israel had to respond to the egregious terrorist attack. And what was striking in the initial months of the campaign was that Western allies and even some legal commentators came back to this obvious urgency of defeating Hamas as a way to reframe what were from the start quite obvious violations of IHL by Israel in Gaza. My sense is now that 2.5 years later, that narrative has largely failed to work. The overwhelming consensus is that Israel has systematically and egregiously violated IHL in Gaza, even committed war crimes and crimes against humanity, and that the question of the urgency of defending itself against Hamas is immaterial to that. That doesn't obviously mean Palestinians have accountability, even that the violations of IHL have stopped. So this isn't a happy story of compliance and hope. But I do want to stress that it means that the overwhelming consensus now, I think, among observers with legal expertise is that Israel's conduct in the context of an urgent need to do something to defend itself must be scrutinized under IHL, and that it manifestly failed to live up to that standard. So IHL is under pressure from the lawlessness that comes with the rising number of obviously conflicts that cannot be justified under the resort to force. But its authoritative character and also its doctrinal applicability, the separation from these highly politicized, moralized questions of who resorted to force, why, that to me stands relatively intact.
Cordula made the point that the effects of this so-called unraveling of the world order have less significance for the people in those parts of the world that have long suffered endemic armed conflict and IHL violations. I'm wondering then if the kind of normative aspects of IHL land differently on some parts of the world than others. And I think, Janina, your comments also lend to that speculation. But I do want to now home in on specific normative aspects and ask you all about, well, just predictions for what IHL might do in connection with new developments. We're all also familiar with the notion that IHL is designed to always fight the last war, not the next one. And so I'm curious what you all are thinking about whether IHL is going to be up to the task of dealing with developments in the realm of autonomous weapons, in the realm of artificial intelligence, in the realms of cyber, and I guess generally in the competition between technological developments and norms, which one has the upper hand? Cordula, maybe we could start with you.
I think it's a very, very good question. The starting point, I think, normatively is to say that there is no competition in a way between technology and international humanitarian law from the perspective of international humanitarian law, in the sense that the history of warfare has always been the history of new technologies as well. And it is commonly agreed, and it has been repeated by the International Court of Justice, that all new technologies, all new weapons are always subject to international humanitarian law. As the ICJ put it, those of the past, those of the present, and those of the future. So in that sense, all new technologies that will be deployed on the battlefield are already subject to the principles and rules of international humanitarian law, meaning that they can never be weapons that are indiscriminate, and they can never be weapons that cause superfluous injury or unnecessary suffering, as the phrasing goes in international humanitarian law, or indeed that if they are not unlawful per se, that their use has to comply with the principles of distinction, proportionality, precaution, the prohibition of superfluous injury and unnecessary suffering, etc. So they are subject to international humanitarian law. And then you go back to the basic issue of compliance with international humanitarian law. But I think your question also goes to the development of new international humanitarian law and whether we need new law for these new technologies. And in fact, whether you need new law for a new technology, it depends on whether there's a gap in the law, right? And the question about whether there's a gap in the law depends on what you want the law to achieve. From the perspective of a humanitarian organization like the ICRC, but I would also say from the normative perspective of international humanitarian law, the point of it is to protect people from, again, indiscriminate attacks and so forth. And so the question is, with respect to cyber, with respect to autonomous weapons, with respect to AI, is the law sufficient today to achieve that? And I would decline that a bit into, then you need to become a bit more specific. So cyber operations, for instance, which are operations basically of between computers, if I can put it like this, but which have an effect then on the other side in the real world, in the kinetic world, on civilian infrastructure, on systems, on electricity networks, on hospitals, etc. So if you conduct such cyber operations, is international humanitarian law sufficient to prevent, in particular, that the infrastructure on the other side, the objects on the other side, indeed also the people, but most often the objects, will be protected against, being destroyed if they're civilian objects? And that will depend on how you interpret some of the rules of international humanitarian law. How do you interpret whether, for instance, data is protected or not as a civilian object? There's a question there because civilian objects or objects in general in international law, humanitarian law generally, are things that you can touch, so are physical things. But if you interpret object in that way in the digital realm and you don't protect data, then you might need new rules because then you have a gap in protection. On autonomous weapons, it's the same question. And there, from the perspective of the ICRC, I would say on cyber, the position of the ICRC so far has been to say, well, it's a matter of how do we interpret international humanitarian law in a way that fits the contemporary reality of armed conflicts. When it comes to autonomous weapon systems, you have to add the question of risk. So again, the history of new development of law for new technologies is also always a competition between those states that say, no, these new technologies are subject to the law and you just have to trust us to respect the law and then it will be fine. And civilians and other victims will be protected against unlawful use of those technologies. And others who have said, no, with the particular technology, there is too much risk that this technology will not be used in compliance with IHL, and therefore we need to restrict it or ban it entirely. That was the case for chemical weapons, biological weapons, anti-personnel mines, cluster munitions. For all of those weapons, the discussion has always been about this. Is the law sufficient? Can we trust the law to be sufficient? And can you trust those who use the technologies to use them in compliance? And for some of these weapons, it has been decided that not. From the perspective of the ICRC, some autonomous weapons are unproblematic, and you just need to put a framework around them so that they're used in compliance with international law. We already have a lot of autonomy in weapons, such as in anti-missile defense systems, for instance, they work autonomously. But what we are starting to see on the battlefield with increased autonomy in robotic systems, particularly drones, but it can be any systems, poses real questions about the capacity of such systems to comply with the principle of distinction in complex environments, ethical questions about really whether you want algorithms to make decisions about life and death, societal questions, very profound questions, which is why, from our perspective, for autonomous weapons, we do need a new treaty. Now, your question is about the protection and will we get one? And I think it will be very, very difficult. But if we don't get one, we will live to regret it.
I want to add one element to this technology question, and that has to do with the malleability of IHL. I mean, on the one hand, IHL has to chase technology in a manner of speaking. On the other hand, it also seems that there are things chasing IHL. For example, post 9/11, so-called war on terror, expanded concepts of what constitutes armed conflict, expanding concepts of what constitutes military objectives, what constitutes proportionality. Ona, in connection with all of these variables, whether it's technology or changing behaviors of parties to armed conflict toward IHL, I'd just be interested in your thoughts on how do states perceive the need to maintain integrity of IHL in this changing environment?
Yeah, it's a good question. And I think you're pointing to an issue that I think is become more clear is a problem. So one of the challenges of the post 9/11 era is that states, and particularly the United States taking the lead, interpreted IHL in ways that suited the needs of the moment, sometimes in ways that are highly contested. So, for instance, U.S. took the position that took an expansive interpretation of civilians directly participating in hostilities. It took a fairly broad interpretation that any member of an organized armed group can be targeted whether they participate directly in combat operations or not. There was an ongoing debate between the ICRC and the US and UK and a number of other states on one side who were, wanted to be able to fight the global war on terror and wanted rules that they thought would allow them to target those that they thought were dangerous. And so adopted fairly expansive interpretations of these terms. What we're seeing now is that changes in technology have shown us that those interpretations actually create new risks that were not anticipated or I think appreciated at the time. So just to take an example, in Ukraine, almost everyone has an app that they use to pay their taxes, that they use to pay parking tickets, that they, use for sort of day-to-day interaction with government. That same app has a function within it that allows them to take pictures of Russian troops or of, militarily significant events that are happening in their area and upload it, and it gets sent directly to the Ukrainian military. Well, if you do that, by the interpretation the U.S. has adopted of civilians directly participating in hostilities, you're a civilian directly participating in hostilities. Not only while you're actually taking the picture and while you're uploading it, which I think even the ICRC would say sort of at the moment of participation in that way, you're arguably a civilian directly participating in hostilities. But as long as you have that app on your phone, you're likely can be considered to be targetable. That was not anticipated when we're adopting an interpretation of what civilians directly participating in hostilities are during the global war on terror. That was not what we imagined we were doing, or the U.S. imagined it was doing, but now has all these consequences for civilians who have access to technologies that allow them to participate in various ways. Other ways in which civilians can participate now is through crowdfunding. I mean, if you're on Blue Sky or Twitter, you follow any Ukrainian, inevitably you've come across one of these fundraising requests to support funding, protective gear and the like for somebody who's fighting on the front lines. If you respond to that, you're financing military operations, and that's enabled through the technology of the internet and crowdfunding techniques. And these are things that are now making people more vulnerable. And one of the ways in which states are beginning to respond to these increased threats that we talked about at the beginning is through mirroring what Ukraine is doing. Everyone admires very much the ways in which Ukraine has brought civilians into the defensive umbrella of their efforts to try and respond to the illegal aggression of Ukraine. Europe is adopting this. Many countries in Europe are adopting the civilian defense force idea. That was in the news recently that Canada has developed a war plan for U.S. invasion that is based on the idea of civilians responding by providing this kind of support to the Canadian military and adopting kind of Taliban-like rules, as it was reported. I think this kind of crowdfunding of defense through civilian participation using these technologies. So what I think we now have to contend with is that technologies are bringing civilians into the war effort in a new way, and that these interpretations of the law that remain contested, I should say, remain matters of disagreement. The U.S. and UK and a few others, on one side of kind of a very aggressive interpretation, and a number of other states and the ICRC kind of on the other side on some of these, have these consequences that I think were unanticipated. So it's not just, are we seeing new gaps that are being created, but are these interpretations that we adopted creating new vulnerabilities in light of these technologies and the ways that they're being used by civilians that we need to contend with? And I don't think we need new laws, really. I think what we need to do is revisit these interpretations and I think question whether these interpretations that I think remain not widely adopted by all states, whether, states that don't share that view should be more vocal about their interpretation so that we actually have an opportunity to use existing law to better protect civilians who are participating in these kinds of technologically enabled efforts to try and protect themselves and help defend their countries. So this is another way in which technological evolution is creating new challenges that we need to face.
Mike and Janina, before we go on and conclude the last few minutes we have to talk about implementation and enforcement, I want to ask the two of you if you have anything to add on these questions of the changes in technology and the changes in interpretation and application of fundamental principles, how you see that playing out tomorrow, next year, next decade.
Well, on my part, I'm one of those that Cordula was talking about. I believe that the law is robust, that it's flexible, that it's very responsive to changes in the nature of warfare. And I say that based on experience. I mean, back when I was a targeting officer and a baby JAG, we were extraordinarily worried about beyond visual range engagements, air to air. We were extraordinarily worried about indirect fires. They're called over the horizon engagements. We could not possibly contemplate how we could comply with LOAC with these sorts of technologies. When young JAGs come through the War College today, majors, lieutenant colonels, they don't even think twice about it. They know exactly what to do. We had big debates about remotely operated drones. Today, pretty much everyone knows how to engage multi or remotely operated drones on the battlefield in compliance with the law of armed conflict. I had something to do with cyber, as Cordula knows, because she was the ICRC representative on the team that put together the Tala manual, which I directed, and which, of course, Gabor, you were part of. And my experience in that process in which we really ripped apart cyber and the law was that there weren't too many places where it was problematic. Now, Cordula certainly mentioned one. That was data, whether or not that is an object such that if you attack data and it is civilian, you are engaging in an attack on a civilian object. Another was, what's the meaning of the word attack in the law of armed conflict? If I'm conducting a cyber operation, the cyber operation doesn't cause physical damage to the target, but it interferes, for example, with functionality. Is that an attack? But in both of those cases, I think that interpretation is the right answer, and we're starting to see forward motion. For example, with regard to attack, most states are of the view that a relatively permanent loss of functionality qualifies as an attack, and if you're engaging a civilian cyber infrastructure, and that's the consequence, you're there. So now we've started a project that's not unlike the Tala manual for artificial intelligence, and I'm directing that as well, along with Sean Watts at West Point. And we've been looking at it for about 6 months, and I have to be honest, I keep coming up with the same response. Yes, this is a little bit different, but if we calm down and we think through this logically, we'll probably get to a reasonable response. So just to give you an example, everyone wants to talk about the opacity of artificial intelligence. You can't predict what's happening, but listen, uncertainty on the battlefield was around when Mike Schmidt was a second lieutenant targeting officer. Anyone who's been to war knows that the fog of war is something very real. When I was in uniform, my unit with F-15s in daylight shot down 2 of our own helicopters, killing 26 members of our unit, of our team. So the law already accommodates uncertainty. We don't need to spike up and say, oh my God, we have a system that is uncertain, especially since some of these systems may actually enhance the ability to comply with the law of armed conflict. If I've got a system that can fuse intelligence from lots of different sources, if I've got a system that can weed through intelligence to find me the piece of intelligence I need to ensure that I've properly identified a military objective as such, and that I'm not likely to cause excessive collateral damage, and help me exhaust the options for engaging the target consistent with the obligation to take precautions in attack. I think we're there. So, I mean, my lesson, my gray beard, gray hair lesson is we probably need to calm down. When we don't need to be talking about killer robots and, coming up with these wild ideas. We need to calm down in a very measured fashion. We need to determine how this body applies, and if we in fact do have a problem. As for a new treaty, I'm absolutely opposed to a new treaty. Why? Because until we fully understand the technology, we don't know what gaps we have that a treaty would need to fill. And we always run the risk that a treaty will be less inclusive than simply interpreting the extant law. So in my view, treaty way premature. Let's do our homework, and then we can figure out if we need a new treaty, if we need to engage states on various interpretations, as we did with attack and data in the cyber context.
Janina, I leave to you the difficult task of weighing in on kind of this last round of conversation about technology and changing visions of the application of fundamental principles. but also in the few minutes that we have left, I do want to hear a little bit about everybody's thoughts on implementation and enforcement, and in particular, the kind of future utility of the major institutions like the ICJ, the ICC, and the Security Council. So with that tiny question, I throw it on to you.
Yeah, I'm not entirely sure I can do justice to that. I mean, I don't have much to add to the whole question on technology, except to maybe put it even more bluntly than Mike and Ona have, which I generally think that anyone who picks any particular technology and says, well, this is the fundamental challenge to international humanitarian law, we just can't comply anymore, is just making mischief. And the point is not to, ask, like, how does a technology challenge IHL, but to say, what are the specific requirements for proper implementation? And do we encounter the rare technology where we want a categorical prohibition? But generally speaking, I think what this discussion threw up for me is the notion that we need to not just ask the question, how do we apply IHL, but also where are the limits of the applicability of IHL? And to be honest, that is something that I worry much more about, because I think it's important for us to remember what IHL is and where it comes from. It comes from a long line of general principles of the permissibility of violence in war. And they're specifically evolved to deal with a very specific context of war, right? And so what we have here is particularly the notion of status-based killing, right? That you can kill an individual because they are a member of the adversary's armed forces or because they have a continuous combat function in an organized armed group. And that is something that has evolved specifically to deal with the circumstances of war. In any other context, killing a person under that circumstance is morally abhorrent and strictly prohibited under human rights law, which suggests that you can only ever kill a person because through their conduct, they in that moment pose an imminent threat to someone else's life. So one of the things that we have seen, rather independent of technology, is the temptation by states to wish to expand the paradigm of applicability of IHL in order to bootstrap themselves into having kind of status-based killing. One of them was mentioned earlier, the kind of example that particularly animates us right now are the boat strikes in the Caribbean, right? Where the idea is like we have a non-international armed conflict here, so we can kill people that not through their conduct pose a threat to anyone in that moment, but that we designate as adversaries, as terrorists, as a matter of their status. And I think that is incredibly dangerous, as with a lot of these kinds of interpretation, the original sin here is the global war on terror, where the United States started to do that, right? But to me, that is really incredibly problematic. We have authoritative principles that allow us to identify an armed conflict. International armed conflicts are really easily to identify, but non-international armed conflicts are subject to criteria. And with all our wish to kind of shore up international humanitarian law, build political momentum for compliance, for enforcement, argue in favor of its authoritative character and the moral importance that it has in war, we also need to stand up to say, and here are the limits of applicability. Here's where you cannot bootstrap yourself into status-based targeting simply by declaring that you're in an armed conflict, right? Because I think that at the bottom line serves neither kind of our wish to morally protect human life, nor does it actually serve the international rule of law. We have evolved over some time now to have a kind of relatively consensual understanding of how human rights law and IHL interact specifically in the context of the conduct of hostilities or law enforcement operations. And I think one frontier for me to stand up for the integrity of international law overall is to uphold that line, where we simply don't have a non-international or an international armed conflict and where we must insist on human rights law. That isn't to say that narco-terrorists are unproblematic people or that the global drug traffic is trivial. But I think for everyone who doesn't want criminals in their own country to be summarily executed on the street, but to be apprehended and prosecuted in line with the rule of law, for everyone like that, there's also reason to stand up to say international humanitarian law in its applicability has limits. And law enforcement operations must respond to the standards of human rights law. That would be my general concern.
I do want to close, and since I, for better or worse, styled this conversation as a report card on IHL, and my wife told me, well, that means you have to actually give it a grade at the end. I would say that as concerns norms, B+ to A-. I would say as to implementation and enforcement, something considerably less, maybe a C, maybe a C plus. And I'm curious, just very briefly, what your impressions are on those grades and that concept of division between norms and implementation and enforcement. Cordula?
Yeah, can you still hear me or see me? Because my computer's going a bit crazy, so I don't know.
I can see you and hear you.
Okay, perfect. I can't see you or I can hear you, but I can't see you anymore. So obviously on the normative and the substance, it's A++. On enforcement, it's not a pass, I'm afraid. And I think I want to explain that and go back to what you said about Luke Henkin, which I think is also true for IHL. We need to realize that international humanitarian law is respected by many parties all the time, every day. And it has, over the years, saved thousands of lives. So this is true. But it is also true that it has failed to save many other thousands of lives because of lack of respect. And in a way, that is, what matters and what we have to concentrate on. So that's why I would give that report card.
So unless somebody has a significant disagreement with that, yes, no, then I want to thank you all. But if you can hold on for a few more minutes, of course, we'd like to field some questions from the audience. Freya?
Absolutely. So we have a few great questions. The first is from Darcia or Darsha. I have a question regarding relating to Geneva Convention 4 and Common Article 1. What are your thoughts about the positive obligation of states to ensure that third parties also comply with the convention? Hasn't the response of other states to the numerous breaches discussed in this webinar been woefully inadequate?
Well, maybe back to you, Cordula, on the distinction between respect and ensure respect. And Ona, you want to have something to say about this too? Everybody.
Yes. Respect and ensure respect is actually not only for the Fourth Geneva Convention, it stems from what is called Common Article 1, just for clarity, which exists in all the Geneva Conventions. It also exists in the first additional protocol, to which about 160 states are parties. And from our perspective, it's actually a customary law rule of international humanitarian law. It entails this obligation to not only respect international humanitarian law by yourself, but also indeed to take measures in order to ensure that the parties to the conflict also abide by international humanitarian law. And this has been repeated by many states. It has also been repeated several times by the International Court of Justice. A very small minority of states, though, and I should be transparent on that, disagree with this interpretation. Now, have states done everything possible? Obviously, they haven't. But again, there, I think the picture is nuanced. Many states do, I think, try to influence parties to conflicts in order to ensure better respect by those parties to conflicts. Of course, those states that have a particularly strong relationship with the parties to the conflicts, either because they support them economically or because they transfer weapons to them, have a particular responsibility on that. So I think you also have to see this obligation as an obligation of conduct and not an obligation of result. And I think some states have done relatively well on this. Other states, I think, have been disregarding, and again, this is the main problem, have been considering international humanitarian law as only a secondary consideration compared to their military alliances, their economic interests, their support to parties, sometimes very legitimate support to parties, but they have disregarded the fact that even if they support a party which they consider to be legitimate, to be fighting the good fight, as you say, they still have to do this by abiding by international humanitarian law, and much more needs to be done.
Ona?
Yeah, I mean, I very much agree with that. I think that this question is such an important one because I think if we're going to move towards stronger enforcement, that a significant answer to that question of how do we do better does have to run through other states holding up their part of the bargain under Common Article 1 and taking steps to ensure respect of IHL. We're not going to try every violation of IHL in International Criminal Court. That will never happen. And so what it comes to is decentralized enforcement and states holding one another to account, and certainly not taking actions that enable or strengthen violations of international humanitarian law. And to go back to something that was said at the beginning of the conversation around this mystery of why is it that Ukraine has done such a good job complying with IHL, given that one might think, they have a good case, or as good a case as anyone would have to be able to fight with sort of taking the gloves off, given that they're facing an existential threat. And I think at least part of the answer to that question is Common Article 1, because Ukraine recognizes that obviously this is a key part of how it differentiates itself from Russia, but also it depends on support from states that actually believe in international humanitarian law and the rules of the system. And they recognize that they depend fundamentally on that support, intelligence support, financial support, weapons provision, et cetera, to be able to survive. And that if they are openly violating international humanitarian law, they're not going to get that support, and that those states are going to withdraw that support. So I think Ukraine recognized that its survival depended on its compliance with IHL precisely because of the principles that underlie Common Article 1. And so one of the steps, I think, towards strengthening and filling this gap between our aspirations and the reality is to do a better job of holding states to account, and for states holding one another to account and upholding their obligations under Common Article 1.
Janina?
Yeah, I would add to this, be even sort of less polite about it. It's not just Common Article 1, right? States have other sources of obligations for ensuring respect for IHL. Under the Arms Trade Treaty, there's a general obligation not to materially assist internationally wrongful acts, which manifest in systematic violations of IHL clearly are. They're very forward-leaning and early triggered duties of preventing genocide. And what we have seen in the last couple of months is that states are not systematically guided by these obligations in their foreign policies. Ukraine is the wonderful exception, but we've seen many other theaters of war where states have acted purely on geopolitical impulse without regard to their own obligations under IHL, under international law, with regard to how they must kind of position themselves vis-a-vis the parties. When I started studying international humanitarian law 5 years ago, IHL was already in a crisis of compliance, right? It's in some sense structured in a way that belligerents always have an incentive to go for the loosest interpretation and to circumvent it unless they're held to account by third states, right? Third states' horizontal enforcement is all there is really in international, or at least almost all there is in international law. So for me, the crisis that we now see in IHL, where we really have, some high-intensity, high-tech war that is seemingly unrestrained by IHL, to me is a crisis of inadequate third-party response, of really important militarily capable states in the international system that dominate important alliance systems, not being guided by their own obligations as third parties and how they must position themselves towards ongoing armed conflicts when either party in them systematically violates international humanitarian law. To me, this is one of the critical sort of inflection points that we are at, and also where we need to politically and with kind of legal argument find levers to find reasons again why third states that are not direct belligerents in an ongoing armed conflict, why they must find back to their own fidelity to law and to try and ensure respect for IHL because of Common Article 1, but also their general obligations under international law.
Mike, a quick thought on third-party obligations?
Yeah, I've written about this a lot. I've testified in courts about this. The issue is ensure respect, and everyone agrees that the obligation in Common Article 1 to respect and ensure respect, law of armed conflict, everyone agrees that is the law and it is customary in character. The question is, what is the extent of the obligation to ensure respect? Does it require state A to take action when state B violates the law of armed conflict? Action to influence state B, So, for example, if it's engaged in foreign trade with state B, does state A have a legal obligation as a party to the treaty, and because of the customary character of the rule, to cut off the trade? And so there's been substantial litigation, and as far as I'm aware, in almost every case, that argument has lost, that is not the rule of ensure respect. What does ensure respect mean? Well, there are great scholars like the late Fritz Kalshoven or Adam Roberts who have explained that ensure respect is about if you are in control of territory, then you have an obligation not only to have your forces respect the law of armed conflict, but to ensure that everyone you're in control of respects the law of armed conflict. Now, that's different from the issue of supporting a bad actor, a bad guy. Janina is 112% correct that there are rules that say you may not support states in their unlawful activities, and the Arms Trade Treaty is one of them. I would also include Common Article 1, because to Mike Schmidt, if you're in any way supporting another state's violation of the law of armed conflict, then you are yourself in violation of your obligation to respect the law of armed conflict. And I would remind you that the law of state responsibility comes into play, because if you are supporting violations of the law by other states, then this is clearly an Article 16 of the Articles of State Responsibility situation, in which you will be responsible for your contribution to that violation. By the way, the ICRC view is this broad view, and I don't think it's right as a matter of law. It's in their more recent commentary, but I absolutely wish it was the law. That's what the law should be.
There may not be
Freya.
universal agreement on that, but I think we should move on because we have a lot of questions.
Yeah, Freya, do we have time for more?
If we can make it very quick, or just a few short comments. The next question posed was, Russia has made Ukraine's environment a target. It is not in this conflict merely collateral damage. Can you comment on the application of IHL and the parallel efforts to develop PIRAC, or the protection of the environment in relation to armed conflict?
Anyone?
Well, I mean,
I
if
think
no
this
one's
one's
going to
for
have,
Kadula.
I'm not sure I understood the question entirely. I mean, I wouldn't want to comment on any specific conflict, not the Ukraine-Russia one or any other conflict. Now, in terms of the protection of the environment in armed conflict, I think that's, again, something where we've seen far too little attention to this issue. The ICRC has published some guidelines on how international humanitarian law applies to the protection of the environment in armed conflict. It does so through a very specific rule that prohibits long-term widespread damage to the environment in armed conflict situations. But much more importantly, the general rules of international humanitarian law, of course, apply as well with respect to the protection of the environment. And you have all the, weapons rules that apply as well against weapon contamination, clearance of explosive remnants of war, etc. But it is, again, I talked at the beginning about the effect of armed conflict on people, and that we should always have this in mind. And what we see in particularly in the Middle East, in Africa, and in Asia, is that you have this perfect storm of a degradation of the environment, the ravaging effects of climate change and armed conflict, and all of these things together affect people in armed conflict situations. And so we need to work on all of these different aspects in order to bring people out of violence, but also poverty and misery and the continuation of these conflicts.
I wish we had another hour, but we don't. And I know people have places to go, things to do. So I just want to end by thanking you all panelists very much for this conversation. Freya, thank you, and to the ABILA for making it happen. And I hope we'll have another opportunity to do something like this in the not too immediate future, but the not too distant future as well. Thank you, everybody. Have a wonderful afternoon, evening. Bye-bye.